holiday, everyone. Good seeing you. And the last case for the year, the Estate of STANVA Falletta versus Bank of New York.
Saving the best for last.
Whenever counsel's ready. Would you like to reserve any time?
Yes, 5 minutes, please, Your Honor.
Okay.
May it please the Court, I'm Bruce Snow, attorney in Brooksville, Florida, representing the appellate in this appeal. Very simply, this is an appeal from a summary judgment wherein the trial court approved foreclosure on a mortgage that had been executed in 2005.
Did this go to sale?
I'm sorry, Your Honor.
Already gone to sale?
No, it did not go to sale. The court approved a stay.
The lower court approved a stay?
Yes, Your Honor.
Without bond, huh?
Without bond because of the questions that had been raised during the summary judgment hearing.
I understand.
Perhaps one of the first things that should be addressed very briefly is the standard of review on summary judgment.
You don't need to go over that.
Okay, very good.
Let me ask you, how would you distinguish this case from what you call Riggs 2, although I don't even think you can find Riggs 1 anywhere?
Well, Riggs 2 was a decision out of the 4th DCA, as I recall, and originally the court had entered an opinion and had made a determination that the foreclosure judgment should be reversed. In Riggs 2, however, the court on rehearing made a determination that the note that was the subject to the foreclosure action had been endorsed. There had been a blank endorsement on the note. And because there had been a blank endorsement on the note under the provisions of the Uniform Commercial Code, the blank endorsement resulted in the holder of the note having the standing to bring a foreclosure action. In the case before the court here, there is no endorsement on the note, either in blank or to an individual. So that is a critical factual distinction between Riggs 2 and the facts of this case.
But you've got Countrywide who executed a affidavit that said they owned the note back in 2005, and then you've got the Mears assignment that says they owned it as of 2005. So isn't that the evidence that Riggs was talking about?
I don't think so, Your Honor. Again, in Riggs, again there was a blank endorsement that indicated that that person held the note and therefore had the right to sue. There's actually no evidence in the case before the court here that the Bank of New York ever received either an assignment of the note. They tried 3 different times to do an assignment. They tried to do an assignment initially. It was assignment on property in South Carolina, and then the second assignment they did was an assignment that was executed some 5 months after the complaint was filed, and then the third assignment was an assignment that was created during litigation, an assignment that was executed 2 years after the complaint was filed. And that assignment had language in there recognizing the problem that they were faced with in their foreclosure matter, saying, well, this assignment occurred back in December of 2005.
But don't you have the additional affidavit by Countrywide?
Well, the only thing the affidavit says is that the bank is the holder of the note. There are no facts set forth in the affidavit to explain or to show what is the basis of them being the holder of the note. The complaint alleged that they were the holder of the note. However, that was contradicted by the mortgage that had been attached, which showed that the Bank of Arizona was actually the holder of the note if you look at the face of the complaint. And all the affidavits that have been filed by representatives of the bank or Countrywide, who's the servicing agent, all they just do is make the naked assertion that the same thing that they asserted in the complaint, that the Bank of New York is the holder of the note. However, when asked...
Where is the note? Is it in the court file?
Your Honor, it's my understanding it's in the court file.
He surrendered it at the time?
Your Honor, I think at the final hearing they did a notice of filing of the note.
Is that evidence that they're the holder of it?
No, it is not, Your Honor. If it is not, if it's not endorsed, the mere possession of a note does not give one standing to bring an action to foreclose on that note, unless there's also an indication that that person has received an assignment of the mortgage. And they attempted 3 times to do an assignment of the mortgage, but each time was after the complaint was filed. And the cases we cited in our brief, the back funding case and the Jeff Ray Corp case, both indicate you must show that you have standing at the time you file your complaint.
And that is the crux of your argument, is it?
Yes, it is, Your Honor.
That at the time that they filed the complaint, there was not evidence supporting their ownership of the note.
That's correct, Your Honor.
So under your theory, they could certainly dismiss and refile.
I think they have the opportunity to dismiss and refile. If they contend that the Bank of New York is the holder of the note, then they have to produce documentation showing in what fashion they became the holder of the note. The question becomes, can they create an assignment some 2 years after they filed a complaint and saying that becomes our evidence to support the fact that we are the holders of the note? There's no proof of an ineffectual assignment that had occurred contemporaneous to the event, and that's generally when you find the situation where the courts have talked about equitable transfer.
At this point, the issue is whether this was appropriate for summary judgment.
That's correct. We're not arguing that they couldn't go back and to file a new complaint and try to...
Amended complaint wouldn't do it?
I'm sorry, Your Honor?
If they did file an amended complaint, that wouldn't be sufficient? They would need to dismiss from your standpoint?
I think the way I read the case is the Jeff Ray case and the back funding case, that they would be required to dismiss their complaint and to refile and to show the basis of their standing at the time that they file their complaint. And they have not done that in this case. And I think they've recognized that they have that deficiency when they tried to argue in their brief that, well, this was really a case of equitable transfer. But that's the first time that issue has appeared in this proceeding, was when they filed their answer brief on appeal. We respectfully contend that is not the appropriate time to contend that you're the holder of a note and of a mortgage by virtue of equitable transfer. The first time you raise that is on appeal. That was not pled in their complaint. It was not the subject of their affidavits. It was not the subject of their motion for summary judgment. There was no finding by the court that this was an equitable transfer. They had been proceeding on the track that there had been an actual assignment, but they were then faced with the back funding case and the Jeff Ray Corp case that says you have to have standing at the time you file your complaint. And I think once they recognized that they weren't going to meet that standard, says, well, we're going to create an assignment some 2 years later and file that assignment, and then appeal for the first time, raise the issue of equitable transfer. We believe that they're going to go forth with an equitable transfer argument that should be pled, that we should have the opportunity at the trial level to file responsive pleadings to an equitable transfer argument. Then they would be required to show evidence supporting an equitable transfer. And generally the evidence to show an equitable transfer is going to involve an attempt ab initio to have made a assignment that for some reason was ineffective at the time that the attempt was made. They must show then that there was also a purchase of the note. The affidavits and no other evidence even established that the note was purchased or that any consideration was paid for the note. So those are obstacles that they would have to go back and proceed with through an amended complaint or through an, as we see it, through a dismissal and filing of a second complaint.
Did the trial court order your clients to put the mortgage payments into the registry of the court?
No, Your Honor. The facts of this case was that the note was executed by Thomas Falletta, who died and had an estate pending in Orange County. He was survived by his spouse, STANVA Falletta. She died, and she had an estate pending in Orange County. And those estates have been contested. I think there have been 3 appeals in those estates before this court that's been going on 3 or 4 years without litigation. But in answer to your question, no, there was no requirement that any escrow money should be paid in the court registry.
Would you like to reserve the rest of your time for rebuttal?
I think that would be appropriate, yes. Thank you.
Before we get started with the appellee, I should have mentioned and did not that at the conclusion of this oral argument, we will invite attorneys and offspring for coffee with the court.
Thank you. Good morning, Your. May it please the Court, Thomasina Moore on behalf of Bank of New York as trustee. Your Honor, we can agree with the appellant on several important points. However, we cannot agree with the appellant on the legal import of many of the facts of this case. I believe that where the appellant and the bank essentially...
Who is the note endorsed to?
The note is not endorsed, Your Honor.
Okay, so do you own the note?
Yes, Your Honor.
Your client?
I believe that... I'm sorry.
Go ahead, I'm sorry.
No, I interrupted you and I apologize. I believe that the Bank of New York is entitled to enforce the note as a non-holder in possession under 673-3011. I find that the facts of the case as far as ownership of the note and mortgage are in many ways very similar to this Court's recent opinion in the Taylor matter, which was decided after
When you filed your foreclosure complaint, you alleged that the plaintiff was the owner and holder of the note, right?
Yes, Your Honor, we did.
They weren't?
Well, no.
You know what a holder is, right? I mean, it's somebody that...
Yes,
that's a
Your
legal
Honor.
term, right?
It is a legal term under the UCC. We argue that, and our complaint has a paragraph that they are the owner and holder note or entitled to enforce it as agent or as the owner and holder. So that would be inaccurate, Your Honor. However, I don't think that would be fatal to the case here. The question is really...
Well, it might not be fatal to your entitlement to pursue the debt, but is it fatal to the point that it requires you to start all over again and do it right?
No, Your Honor, I think we did it right this time, and I don't think we need to start all over again. There were bumps on the road, certainly, and I'd like to clarify a couple of facts on that. There are 3 assignments which have been filed. The first assignment was not an assignment that related to this case at all. It's been referred to in both briefs, unfortunately, as a scrivener's error, an error just as to the legal description. In fact, it was another party, another OR book and page number, another one. I think we can set that aside. I agree with you, it's not, and that's why I was saying, unfortunately, even in our brief, we had referred to it as a scrivener's error. It's just the wrong exhibit. It was just a pure mistake on the part of the attorney that filed it that did not catch that wrong exhibit had been attached to the notice of filing. So there are, in fact, 2 assignments that were created here, both of which were dated after the filing of the original complaint in June of 2006. I don't think that's fatal here, and I think the case law supports that. I agree that you have to have standing at the time of filing of the complaint, but I don't think standing is dependent upon the date of execution of the mortgage, and I think that it gives effect to the Florida Supreme Court's opinion going back to John versus Gillian, which said specifically that you can have equitable title in the absence of any type of assignment. I'm sorry, Your Honor?
Was that pled?
Yes, Your Honor. It was a pled that we were holder or through assignment, that through the execution or assignment. So
now,
we did.
How does that plead, some sort of equitable entitlement?
Your Honor, I don't think it specifically pleads equitable entitlement, but I also don't think that there's a requirement here that we would. If we were here on a case involving a motion to dismiss.
But isn't that a completely different theory of your entitlement to foreclose upon the property? No.
The basic principles are that you have the ability to enforce the note and mortgage, and I think that that doesn't affect the principles that you are entitled to enforce the note and mortgage. The cases that have been relied upon by opposing counsel that said that there was insufficient pleading all dealt with a motion to dismiss. If we were here on a motion to dismiss, it might be a different outcome. But the fact is no motion to dismiss that challenged the sufficiency of the complaint was ever filed by the defendant, although they had more than a year from the time of the filing of the affidavit regarding ownership of the note and mortgage referenced by Judge Cohen, as well as the additional corrective assignment of mortgage. So we did have evidence in the record that did put the issue of the date of the effectiveness of the assignment for over a year prior to summary judgment. I think that at the summary judgment stage, we're beyond the 4 corners of the complaint and the exhibits, and you're entitled to consider everything before the court and all evidence. And I think that at that stage, it goes beyond the pleading and goes to the evidence in front of the court. And the evidence in front of the court, which was not controverted, was that they did have an equitable assignment on December 21st of 2005. I think given the equitable assignment date, which is unchallenged, that is sufficient to show that there was standing at the time of the filing of the complaint. Additionally, I think that there is sufficient evidence to show that the pleading requirements and the procedural requirements, which opposing counsel has stated must be imposed here, although there is really no case law that supports many of these pleading and procedural requirements that he's asserting now, were really met here. We have the argument that there was an assignment in the complaint. We have the evidence, which he argues that we needed to show that we had acquired the note and mortgage at the time of the filing. So I think we meet those. And to go back to the earlier question regarding being a holder or a non-holder in possession, there's sufficient evidence here to show that the Bank of New York at the time of filing was a non-holder in possession. As I said, it's very similar to the Taylor case in that this is a Mears mortgage. In the contract and in the mortgage documents, it allows for Mears to execute the assignments on behalf of the First National Bank of Arizona, which it did do. In that assignment of mortgage, there is also an assignment of the note. So we do have the same evidence that there was present in Taylor that gave the indicia of possession. We had possession of the original note. No one's disputing that what we filed was the original note. We had the assignment which said we're assigning the original note and mortgage, and we did assign the original note and mortgage 6 months before the complaint was filed and even before default occurred. And so given those two facts, I think it is sufficient to show that they're non-holder in possession with the rights to enforce. And then we did file the certified copy of the loss note and the affidavit of loss note
Mr.
mortgage.
Snow says that the lower court stayed your judgment. Did you appeal that stay?
No, Your Honor, we didn't. And that's a pure business decision. There's nothing in the order which reflects that the trial court had any concerns about the judgment, and as a matter of fact, the record shows that they didn't, because Mr. Snow filed a motion for rehearing, which was denied. So I think the judgment and a denial of a motion for rehearing shows that the court was quite comfortable with their ruling down below.
It just creates a practical problem when you try to reconvey the property and there's an appeal pending, I guess, with title insurance and things like that.
It does, Your Honor, and the bank recognizes the problems that can occur, and I often agree to stays pending appeal because of that problem. You have a third party that comes in, they're a bona fide purchaser. Possibly you could argue that, but it does create serious problems. So we don't challenge usually stays pending appeal. As I said, we think that the crux of the case is, if you look at the Johns case, the Glenn case that follows it, WM Specialty, is not a question of when was the date that the assignment was created. Johns recognizes, and this goes back to 23, that you can have an equitable ownership without there being a written assignment. If we now say the assignment has to be done before the complaint is filed, then that really in essence does away with that language in Johns and the cases that follow it that say you can have equitable interest, and that's standing. Our Florida rule on standing, the real party interest rule, is very liberal and very broad in who has standing to pursue a foreclosure. And I think here that given all of these documents that were filed in support, given the assignment that was filed, which has a specific date, setting aside the assignment specific date, the affidavit that was filed, which showed the transfer, there's nothing to really say that that this did not occur in December of 2005.
What was the purpose of the last assignment that was, which I understand to be, when was that done, in 2008? Yes,
Your Honor. The third assignment added the specific date that the transfer occurred. So the first assignment really in this matter, I set aside the first one because it's...
The first assignment was ineffectual?
No, I don't believe the first assignment in this matter was ineffectual. I think the first assignment was effectual. I think it was done because the issue had already been raised by defense counsel below as far as standing, and we had already questioned whether or not there was ownership at the time, so that issue had already been injected at the time that was corrected.
Since you didn't raise specifically the issue of equitable ownership, how did the state of Falletta, how were they put on notice to file a counter affidavit or bring forth any evidence since that wasn't specifically dealt with?
Well, I think, Your Honor, they did actually raise the argument as far as the effectiveness of the assignment and whether or not we could rely on that. They filed 3 affidavits, what were entitled as 3 affidavits in opposition to summary judgment. They were executed by defense counsel as personal representative of the estate, and in each one of those 3, they raised the issue of whether or not the assignment could be dated after the filing of the complaint. They raised the issue as to whether or not we truly had standing. So they actually raised and injected the issue themselves and brought up the issue as far as whether or not the assignment was effective as to standing prior to that. At the time...
I think the question really went more towards your response to that as opposed to their raising of the issue.
Well, then I think that they, by having the corrective assignment filed over a year before the summary judgment hearing, which did nothing but add a specific date, show them that the bank was arguing when the transfer took place. And I think the affidavit itself, which does go more, a little bit farther than I think defense counsel would read it. I think he reads it more narrowly than I do, because the affidavit as to ownership. little further, thank you, says very specifically, we have been servicing this loan since December of 2005, and that we have, the Bank of New York has owned this loan since 2005. So I think by filing those two pieces of evidence, both of which were a year before, that the defense counsel was clearly on notice that this was an issue as far as when did we take ownership of the mortgage and note. I think at summary judgment there was, and again, we're not on a motion to dismiss, so I don't think testing the legal sufficiency of the pleadings is really the standard that should be applied here as urged by opposing counsel. We're at summary judgment, and at summary judgment there was sufficient affidavit, sufficient evidence, even setting aside the corrective assignment of mortgage by virtue of the affidavit that was filed to show that we had taken possession of the mortgage and note prior to the complaint being filed. I think the equitable ownership absent an assignment demonstrates that we had standing and goes in line with Johns versus Gillian and all the cases that followed it. And then I think the Taylor case provides the last piece when it says that even absent the endorsement as a non-holder in possession under the UCC, coupled with the assignment, which specifically says they're transferring the mortgage and note, just as it did in Taylor, and the language in the contract, the mortgage here, that says that Mears will have that ability to execute the documents for the First National Bank as lender, of Arizona as lender, or its successors, all goes together to show that the court had sufficient evidence to grant summary judgment, none of which was negated by any evidence filed by the defendant, and that the summary judgment should be affirmed. The court has no further questions.
Thank you, Counsel.
Thank you, Your Honor.
Here's the court. I think critical to an analysis of the argument made by the bank in this case is that basically they go to a 2008 assignment of mortgage that was created during litigation that has some language in there saying, well, this assignment really memorializes something that happened back in December of 2005. There's no affidavit from anybody that establishes those matters factually. And I think what you're looking at, if you looked at this complaint that was filed in 2006, that 2008 assignment of mortgage did not exist. And if somebody's doing an analysis, did the plaintiff state did they show their standing when they filed the complaint in 2006? If they're relying upon a 2008 affidavit as a basis of their standing, the answer is that no. In 2006, at the time the complaint was filed, they didn't show that they had standing.
Why is it that they can't correct that, though? Generally speaking, you can correct just about everything in a pleading. It doesn't make a whole lot of sense that you have to pay another filing fee. I mean, it's good for the court system, but really, what does it do in terms of justice?
Your Honor, I'm just going by, again, the cases of back funding and what have you.
Yeah.
They said if you don't have standing when you file, that you have to refile. You have to have standing as a condition precedent to filing your complaint. And the best I can tell, that's the logic of those
that's
decisions.
Not logic, what you just described to me. That's just that it is a rule because it is. I'm trying to discern what the logic is.
And I would agree with the court. I think it's...
Well, I'm not professing an opinion. I'm asking you a question. Do you know what the logic is for it?
The only logic I could see, Your Honor, is that standing would have to be considered a condition precedent to filing your complaint. And that public policy and judicial economy and the right to go get access to the court depends on you having the right and standing to do it when you file your complaint. Mm-hmm. And if you don't have standing when you file your complaint, you didn't have the right initially to be in court, and therefore you should not be able to cure your failure to have had the initial right to come into court. So the way I see those cases is it has to be based on that type of an analysis. Certainly at some point in time, somebody has the ability to refile and try to state perhaps a different cause of action for equitable transfer or something of that nature. And that's how I would see that, Your Honor. And again, what's very troubling from the estate's standpoint in this case, if the bank is relying upon a 2008 assignment, in 2007 there was no standing established, and for a 2-year period there was no evidence of any standing, and even at that there's no affidavits that establish a standing. I would encourage the court to go back and look at the affidavits that the bank had filed in support of their motions for summary judgment. As I recall those affidavits, they just are naked allegations that the plaintiff is the holder of the note and mortgage. I don't recall any language in there that says that they acquired it in any particular fashion.
She quoted some language where they had a little bit of wiggle room there, said, or otherwise legally entitled to enforce the note. I think, was that in there? Or?
Your Honor, I don't recall any language in there that says otherwise.
I don't think counsel would misrepresent.
I don't either, Your Honor. Again, I would refer to the affidavits. My recollection of those affidavits, they were just the naked, they were very short affidavits.
Well, the rule of procedure, which specifies what the foreclosure complaint has to say, is it allows that kind of conclusory pleading in those kind of cases, right? So,
and I understand that.
You don't have to plead how you became the holder of the note. You just have to say you are, right?
And you have to say that you are, but then when you're trying to get a summary judgment, you have to show the proof of it, and that's why we respectfully would argue that there's no proof of it. Matter of fact, the WN Specialty case that has been cited by the bank and the other case that has been cited by the bank, the 1938 Johns case, in support of the premise that, well, you can also proceed on an equitable transfer cause of action. Neither one of those cases were summary judgment cases. Those were cases that had been tried, and those issues had been litigated, and there had been factual determinations made by the court. So those cases are clearly distinguishable. Additionally, the WM Specialty case, where the court says, well, this complaint had been dismissed, but notwithstanding that fact, the dismissal was in error, because they may be able to state a cause of action based upon equitable transfer, but the court tellingly said that that would require an evidentiary hearing. And that, again, is what we're contending, that an evidentiary hearing would be required, and a summary judgment would not be the appropriate device to determine that there had been an equitable transfer. Again, we respectfully would argue that the record does not support that that was ever pled, that was in the affidavits, that was in the motion for summary judgment. The first time we heard anything about equitable transfer was in the brief on appeal.
Are you saying that you could never have a summary judgment if the pleading said equitable transfer?
I think if somebody files a complaint and the cause of action is based upon equitable transfer, and there are affidavits that establish the basis of the equitable transfer, such as there had been an ineffectual attempt to have made an assignment, an affidavit which says this is how we acquired the note was endorsed, even though the assignment of mortgage was ineffectual, we have an endorsed note, or here where we made payment on that note. I think in that circumstance, unless there were some defenses to that perhaps a summary judgment could be obtained. But they would be required to show the factual basis to support an equitable assignment. And that doesn't exist here. But by the same token, if they raise that in their affidavits, the defendant should be able to be given the opportunity to file affidavits in opposition.
All right, thank you, Counsel.
Thank you. I appreciate you hearing us.
All right, we will be in recess.